partner to even expressing one's opinion on social media. Now, this, the government says, will be a matter of discussion between the Collegium as well as the government, but at the same time, the government also insists that the Collegium system itself is opaque. It needs reform, and only judges appointing judges cannot be kosher anymore. At this stage, what's going to give and how? All right, it's now a case of who will blink first. Let's go across to an eminent panel of lawyers who are joining us on this debate tonight. Arima Sundaram is Senior Advocate at the Supreme Court. Aman Lekhi, former Additional Solicitor General. Bishwajit Bhattacharya is also former ASG. And Karun Anandi, Senior Advocate, also joining us. Let me start with you, Arima Sundaram. For the first time, you have the Collegium put on record in public their comments, their rejection of these intel reports. I don't think these intel reports have ever been made public about recommendations of names by the Collegium of lawyers who can be promoted to become High Court judges or judges who can be promoted into the Supreme Court. By making it public, has it got to a stage where the differences between the government and the judiciary on some of these names have become unbridgeable?
Well, I wouldn't say that, because the differences have been there for a period of time, over many years. The Supreme Court has a strong collegium, a collegium which believes in the real doctrine of the separation of powers, that believes that the judgment already laid down by the Supreme Court as to the appointment of judges has to be followed, and the collegium is sticking to the law as has been declared and as prevails today. As to the issue of making it public, I think this goes with the overall increased demand for transparency which had taken place, which resulted in transparency, not now, but over a period of time, on various issues which affected the public, and various issues, whereas earlier the judiciary was considered to be in an ivory tower, whatever happened there was meant to be completely opaque. Over a period of time, on demand of the public, and I must say the media, and the working of the media, the transparency has increased. So much so that today, when this is being commented on left, right and center by the media anyway and by everybody else, and on the government side it is very clear that it has been stated why they are saying no, for the Collegium to reiterate and make very correct and bold statements with regard to what was said about both Saurabh Kripal and Mr. Somashekar. I think the Collegium is just is applying the law as stands in India, as has been declared in India.
So let's look at these cases individually, and I want to ask Aman Lekhi this. In the case, I think the most dramatic is that of Advocate Saurabh Kripal. This was the intel reports objection to him being elevated as Delhi High Court judge. He is gay. He could be biased because of his open support for gay rights. His partner is a Swiss national, to which the Collegium has responded by saying it's unconstitutional to reject the candidature on grounds of sexual orientation. There is no reason to presuppose that the partner of the candidate, who is a foreign national from a friendly country, would be inimical to our country. Many persons holding high offices have foreign partners. Inclusion of Kripal in the judiciary will add to the diversity of the bench. It does seem rather odd and strange in this 21st century, where even the Supreme Court had struck down on Section 377 to say that you can't have an openly gay advocate appointed as a judge in a high court.
Absolutely. I mean, the stand the Collegium has taken is unexceptional. I'm surprised at the comment the government gave, because what I recollect the letter was that passionate pursuit of gay rights. Now, a lot of energy, enthusiasm, fire is something which is expected of Indians, and we want passionate people on the bench too. Now, pursuit will not necessarily mean bias unless there's predisposition. And in any case, as long as the discipline to keep one's perspective out of an assessment for which there's a legal procedure, merely because you have a view, will not in any way disqualify you as a judge.
Yeah.
Unless, of course, you sanitize minds altogether and scrub them of all content. Each one of us has a view, and the views collectively constitute an ideology. Now, merely because some of us have an ideology doesn't necessarily mean that holding of the ideology disqualifies the person from elevation.
Yeah.
Because an objection to the ideology is equally an ideology. Now, with the objection to the ideology is equally an ideology, the question is, what the Supreme Court says, multifariousness, a multi-dimensional approach, and plurality becomes important because we want all voices on the bench. As long as the legal acumen and capacity is there, insofar as the entitlement to be on the bench is concerned, there can be no objection. And more so, because the memorandum of procedure and the Supreme Court itself has ruled, which is binding on the government, as the recommendation has been reiterated, the discretion of the government to in any way avoid, notwithstanding some unhealthy precedents of the past where the Supreme Court itself conceded to the government's demand, it is obligatory that the government does in fact appoint. There have been some chatter about his being the judge of son of an earlier judge and some correlation with the current Chief Justice. What is missed is that the recommendation did not come from this collegium. The recommendation is 2017 to 2018. It's a different scenario altogether. Yeah. And it's a reiteration of the recommendation and not initial recommendation.
Okay.
So the entry of politics into it and the guise of ideology, both are unsavory. And insofar as the entitlement is concerned, it is unobjectionable.
Okay, let me ask Karunanandi, the larger question that the government has been asking, and we've seen this public sparring between the law minister, some judges who have opined on this matter, is that the collegium system is opaque, it needs reform, whether it's the NGAC or any other form of appointment of judges. The larger question they're asking is if in the US, the president appoints judges and has to be confirmed by the Senate, and in the UK, the king appoints judges upon advice by the Prime Minister, India is perhaps the only system where judges appoint judges. That's a larger question that the government is asking. Karunanandi.
We don't have kings in this country. We do have basic rights. And those basic rights have been adjudicated through our constitution, by our Supreme Court and our parliament and our governments, and the law has evolved in a variety of ways. The law as it stands now, as both Mr. Sundaram and Mr. Lekhi have placed, and I agree with them, is that the second judge's case in particular, and now we have, effectively 4 judges' cases along with the NGAC judgment, says that the ultimate decision maker here is the Chief Justice. Has the government upheld the Constitution in this regard? No. Because just in the case of, let us first take the case of Mr. Kirpal. The name of Mr. Kirpal has, the Chief Justice has, and not just this Chief Justice, as Mr. Lekhi pointed out, even prior Chief Justices, have reiterated his name. And now this is the second reiteration. This goes against constitutional norms. Secondly, the law currently, under the Nalsa judgment, is that, as Justice Radhakrishnan says, is that gender identity is one of the most fundamental aspects of life, and this includes sexual orientation. It refers to each person's deeply felt internal and individual experience of gender, and this includes the protection, expressions of gender, including dress, speech, or mannerisms. Right? Now, Mr. Kirpal, having he's not someone who he's I think quite private about his life, but the fact that he has not hidden his sexuality, it's a travesty for the Intelligence Bureau to say this. And indeed, it exposes the fact that the Intelligence Bureau cannot speak for the government, and the government must independently apply its mind through the Attorney General. The reason being that the Intelligence Bureau is not rooted either in any statute or indeed in proper norms, because there's a story that's told actually about an intelligence bureau report about a nominee who was referred to as boozy in his boarding school. And they said that he's referred to as boozy and he's an alcoholic, and the man was a teetotaler. He'd never touched a drop in his life. So by making these reports public and by making their opinion public, I think the Collegium has taken a step in the right direction. Because what is happening now is a greater level of transparency. It is the fact that the Collegium is standing up to a long cherished value of diversity on the bench. And it is the fact that, frankly, the IB objections in many, almost all of the cases that I've seen. In fact, I've not seen one objection that seems to be robust.
But here's the thing. We've had these public sort of sparring, if you will, Bishwajit Bhattacharya, the law minister questioning, Collegium, the fact that there is no system called the Collegium as per the constitution. It was upheld, of course, in a couple of judgments. But as the government says, this is a convenient way. You have every other high appointment in this country, which is vetted by the people in some form, either through parliament or through the elected government. Nonetheless, I'm not getting into that aspect. The larger question, you also had the vice president recently even go to the extent of questioning the basic structure. He says there is no such thing as a basic structure up until a judgment that happened in the 1970s. But nonetheless, the larger question that's being asked is it time for reform of this system? Is it possible that the Supreme Court and the higher judges of the Supreme Court will agree to a system where it's not just 3 judges who decide who gets appointed to high courts and who gets appointed to the Supreme Court, that there will be greater representation in that system? Bishwajit Bhattacharya?
Zaka, the rule of law reigns supreme in India, and the law as on date, as it is, that the Collegium decision after the second reiteration is binding on the government. And unfortunately, government is not complying with the recommendation of the Collegium. Government has been sitting over it. And you talked about, sort of reform. The biggest reform has started yesterday or the day before, when the Supreme Court Collegium, the top 3 judges of the country, emphatically reiterated with the reasonings which the Intelligence Bureau and RAW gave to the government. This shows what kind of total frivolous, insinuations can be made, which has got nothing to do with ability, integrity, and competence of the person concerned. So I personally feel Collegium system is basically evolved from 13-judge bench, Keshavananda Bharati. Then we had S.P. Gupta of 1992. Then we have the 3rd judge's case of 1993 and 1998. And finally, the NJAC. In NJAC, Zaka, the world must not forget that the government faced defeat. And the defeat was faced in 2015, 16th of October. So that is the law. The law as it stands today, the government is bound by the law declared by the Supreme Court. Article 141. Article 144 says all authorities, civil and judicial, shall act in aid of Supreme Court. So therefore, I think government has been ab initio wrong. I'm not saying this government or that government. It is basically 2 wings of the state. And you say that the Collegium system is not as per the constitution. There is a total, if I may say with the greatest of respect, misconception widespread, because the Chief Justice of India has always been consulted in the appointment process. Collegium only impels the Chief Justice of India to consult his colleagues. That is called Collegium. So collegium does not mean another institution. Collegium means the same Chief Justice of India now is obliged to consult and take the opinion of two senior most colleagues for appointment of High Court judges.
All right.
And for the Supreme Court judges and transfer of High Court judges.
Okay,
so
let me go back to Arima Sundaram on that point. Again, in the cases of Advocate Somashekar Sundaresan and in the case of, I think, Advocate John Satyan, both of it pertain to, quote-unquote, their views as expressed on social media. Now, again, Arima Sundaram, in this day and age, to say that a free citizen of this country cannot express his or her views on social media, that is tone deaf.
I think, if you pardon my saying it, that particular excuse trotted out seems very, very hollow. You know, every judge, every citizen has his own views on various issues. That does not mean that if you're a person who has views and who can have independent thoughts, a thought which maybe does not run with the mainstream, you're not fit to be a judge. I mean, we always know, I've been in the bar for so many years, more than 40 years. Let me tell you that we used to know that there were benches which were very pro-labor. There were other benches which were pro-management. There were some benches which were pro-tenants and tenancy rights. Some which felt landlords should get their lands back. Now, they all had their views. There is nothing wrong. They had their views. But once they sit on the bench, they may have views. And because of those views, they may have certain disposition to a case. But that will not be their decision making. Their decision making will be on the law. And to think that such people are going to be guided by their own views and ignore the law is, I think, pardon my saying it, absurd. Because in other words, what if I take this to its ultimate, I lead to an absurdity that anyone who has independent views should not be made a judge.
Yeah.
Anyone who has who can speak his mind should never be a judge.
Yeah.
Anyone who just does nothing except follow the mainstream should never be a judge. Is that what we are saying? On the contrary, what makes the Supreme Court the great institution it is in India is this divergence of views. This ability to look at a problem from different angles. It's only when you look at something from different angles and not from your own view and your microscopic look, when you look at it in a macro way, that you can really lay down law, which is what the Supreme Court does, the law which applies to the whole of India.
Okay.
And in diversity lies the great union of India.
Sure. So
and if you take away that diversity in thought,
let me go back
I'm
to
sorry,
Aman
but
Lekhi
it's
on the
leading to an
question
absurdity.
of what will give now, because I think it's got to a point where it's public. There is bad blood between representatives of the government and our higher judges. It's like I said, the sparring has been happening not in the back channels, not behind the glare of the media. It's been happening on the front pages of the newspapers. It's been happening on primetime debates. We're all talking about it. Has it got to a stage where somebody needs to step in and pull back and say, let's take this behind the scenes. Let's sort this out behind the scenes, because it doesn't seem like at this rate, it's become almost like an ego battle. It's become like who's going to blink first, who's going to give.
No, nothing should be sorted behind the scenes. Now that it's out in the open, we have the issues and the counter issues, the controversies in the public eye. The question here is that whatever steps we take hereafter, whatever decision is taken, appointment or otherwise, the reason for the acceptance or rejection is known, which is a very good thing. In fact, the whole objection was opacity, and as far as opacity is concerned, that is out the window, and now you've got transparency. But I personally feel that as far as this issue is concerned, it's the government is squarely responsible for putting itself in this position, because of the manner in which the series of comments which preceded what has actually happened, because the Supreme Court cannot come to, say, a media interview like we are coming.
Yeah.
The law minister, the vice president, the speaker can all have their views made public. As far as the judges are concerned, the judges cannot possibly address the media. The four who did created a furor, and I'm not in any way approving of that particular conduct. Now, the Supreme Court has responded. because the Supreme Court responded to a criticism. And the Supreme Court responded to the criticism because the criticism was that it's the Supreme Court which is responsible for the delay for reasons which are not forthcoming. And as far as the motivation of the Supreme Court is concerned, that is suspect. And that the motivation will cause the death knell of democracy. Now, the Supreme Court has responded the only way Supreme Court can. And what the Supreme Court has done is that, okay, the government is making allegations. Let us put in the public eye what is actually transpiring. And because it is responding to the government, which is correct, because otherwise the discourse would have been one-dimensional and the view which would have been there would be of one of the parties only. Now, for the whole public, it's all there for everyone to see as to where is the stalling taking place. Okay. The stalling is taking place because the government has an objection to ideology. The stalling is taking place because the government has objection to a view. Now, the government may be having its views on the ideology and the view itself. All the Supreme Court has done is, this is the view and that is the ideology and this is our stand.
All right.
Now, once the stand is there on the view and ideology, it's for us to judge. And any right-thinking person will say, as far as ideology is concerned, ideology by itself cannot be a bar because each one of us has an ideology. Like it or not,
I'm going to take that thought as a final comment with Karunanandi. You go back at what Aman Lekhi said. Just because a person is conservative by nature or liberal by nature, that can't be a barring factor for him or her to be elevated as a High Court judge or a Supreme Court judge. In the US, for example, you have conservative benches and you have liberal benches. You have conservative and liberal judges. In fact, it is argued that whenever there is a Republican president, you tend to have a conservative Supreme Court. And whenever you have a Democrat president, you tend to have a more liberal Supreme Court. So by saying that views expressed on social media are a bar for someone being promoted, then you're basically saying that his or her qualifications as a legal person, as a legal expert, mean nothing.
What you're saying is a very good point, Zaka Jacob. There's a Harvard study that looks at the orientation of judges after they are appointed to the Supreme Court. And whether they are liberal or conservative, they tend to the middle after they are appointed, which is quite interesting. The experience of being on the bench and of adhering as they must to the doctrine of precedent is something that causes them to move towards the center. Now, in our own legal system, and I think that having looked at Bush versus Gore and other judgments of the United States Supreme Court, that our appointment of judges system is imperfect but better. And Indore Development Authority, which is a Supreme Court judgment of 3 judges, speaks of when a judge must recuse themselves. And I think this applies in equal strength to views expressed prior to appointment to the bench. And what it says is that opinions may abound when you are looking at a particular issue. Mm-hmm. But the point is that do you do your job when you are on that bench and you are hearing a particular case? Do you adhere to the requirement of precedent? Mm-hmm. Do you adhere to the lack of bias? Do you listen as a judge? And these qualities, I think, when you look at some of these candidates, when you see people like Saurabh Kirpal and Somashekar Sundaram and Mr. Satyan, the Collegium has chosen well. And it is now really, I think, up to the government to set this battle of perception at rest, because the legality and the constitutionality is clear.
Okay, we've got to wrap up at that. Thank you very much to all our panelists. We'll see how this plays out in the next chapter. Will the government now put an end to this? Because the ball is clearly in their court. Thank you very much for joining us. The dangle that's been going on between the wrestlers and the Wrestling Federation of India President Brijbhushan Singh, it continues. The wrestlers are about to reach Sports Minister Anurag Thakur's residence. This is going to be the second round of talks in 2 days. Top sources have told CNN News 18 that the government will form a 3-member committee that will address the grievances of the protesting wrestlers. Meanwhile, the Indian Olympic Association has called for an emergency meeting today. They will be discussing the issues raised by the wrestlers. A few wrestlers have also boycotted a wrestling event in Gonda in solidarity with those who are protesting at Jantar Mantar. Brijbhushan, on the other hand, has said that he will not resign from the post, adding that he will expose the entire conspiracy behind the wrestlers sitting on the streets of Delhi.
हर एक मुद्दे पे हम अपना आश्वासन चाहते हैं, पूरा विश्वास चाहते हैं, जब हमें कॉन्फिडेंस हो जाएगा कि हाँ हमें एश्योरिटी मिल जाएगी कि हाँ ठीक कुछ भी नहीं होगा, सब खिलाड़ी ठीक है, जो हम चाह रहे हैं वो हो रहा है। टोक्यो ओलंपिक्स के बाद में जो मेरे साथ बर्ताव हुआ था, मैंने अध्यक्ष जी से मिलने का भी टाइम मांगा था, फिर मेरे से आज तक नहीं मिले हैं। उसके बाद से मुझे जब मैं मैच आ रही थी 10 मिनट के बाद में बोल दिया था कि ये तो खोटा सिक्का निकली हमारा। यहाँ पे सब समझदार हैं। देखिए, अगर किसी लड़की को अगर खोटा सिक्का बोल दिया तो उसका मतलब क्या होता है? वो शिकायत हुई है, वो प्रूफ है हमारे पास। वो लड़कियां आज हमें प्रूफ दे रही हैं फोन करके। मैं किसी स्टेट का नाम नहीं ले सकती क्योंकि लड़कियों की लाइफ डेंजर में है और वो बहुत बड़ा मुद्दा है कि वो जिस स्टेट से मैं हूँ डेफिनेटली वो उस स्टेट की नहीं है, लेकिन हमारे पास इज्जत सम्मान है, हम उस इज्जत और सम्मान की लड़ाई लड़ रहे हैं।
नहीं, अभी कुछ नहीं बोलेंगे, प्रेस कॉन्फ्रेंस करेंगे शाम को
करेंगे
जी।
तो बड़े आरोप लग रहे हैं, लेकिन कुछ तो आप जवाब दे दीजिए, क्योंकि दिल्ली में तो लगातार वो मंत्री से मिल करके से बातें कर रहे हैं।
देंगे ना शाम को
देंगे तो शाम तक
शाम
इस्तीफा देने की बात तो नहीं है अभी।
शाम को देंगे, इस्तीफा कोई सवाल नहीं। रुकने की व्यवस्था हम नहीं करते, रुकने की व्यवस्था आयोजक करता है और एक एक देश की टीम को एक एक जगह रुकाता है। ये हमारी व्यवस्था नहीं है। मैं जो है किसी की दया पर नहीं यहाँ पर बैठा हूँ, मैं चुना हुआ अध्यक्ष हूँ जनता के द्वारा।
All right, let me go across to Arun Dhanta, who is joining us live from Anurag Thakur's residence. So this is going to be the second meeting between the wrestlers and the sports minister. What is the sticking point? What is the irreconcilable point that they've got to, where over the last 3 days these wrestlers have been sitting on the streets and yet they've not been able to resolve this problem?
Well, Zaka, yesterday we saw that the delegation of wrestlers reaching here at Anurag Thakur's residence. And remember, Anurag Thakur was out of Delhi. He had to rush back to Delhi and to arrange that meet with the wrestlers. Wrestlers came here, they had dinner with Anurag Thakur and had the discussion for 4 hours. And in fact, we are told by our sources that Anurag Thakur had given them various options and also told them about the restrictions on the ministry, because they can only go to a certain level. They cannot immediately suspend or dismantle the entire organization. There's a proper process under the Olympic charter under which the procedures can begin, because otherwise wrestlers were very adamant with the fact that they want immediate suspension and whatever the other things which ministry or the other body want to do, they can do. But firstly, they wanted the dismantling of the Wrestling Federation of India. And yesterday 4 hours talks happened. It was inconclusive, and then it was decided that they will have another round of meeting today.
Okay.
So it was told to wrestlers that we will sit on a breakfast today, but they didn't turn up. Anurag Thakur, he cancelled all his schedules for today, appointments for today, waiting for the wrestlers to come here, but they did not come. In fact, Zaka, the Secretary of Sports, Sai DG, they all came here.
Okay.
They had plans to sit with all of them, all the wrestlers, but wrestlers did not turn. And then the Secretary Sports and the DG Sai left. Anurag Thakur was inside. And now again, when finally wrestlers agreed to come at 6 p.m., we are seeing that Sai DG has already gone in. And in fact, Sports Secretary Sunita Chaturvedi has also gone inside.
All right.
So,
so the
we'll have
officials have come. We're
out
still waiting for the wrestlers. It'll be interesting to see if they turn up, and if they indeed do, then whether they are not able to, whether they are able to resolve this crisis or not. We'll leave it at that for the moment. Arun Dhanta will be in touch with you through the course of the evening coverage here on CNN News 18 on whether or not at all the government is able to find a resolution to this ongoing standoff between the wrestlers and the WFI president. That's a wrap. In a moment, Poonam joining you with Budget Buzz.
Congress has given itself the pedestal that we are the only national alternative. I think Congress must come to the terms that the public has bigger, greater choices today. It doesn't have to choose the Congress alone.
They'll put women, they'll put children and hide behind them. They are cowards. ये बुज़दिल तो हैं, ये सीधे तो लड़ नहीं सकते. 3 बार लड़ाई की और तीसरी बार तो 90,000 हमने पकड़ लिए थे, चूड़ियाँ पहना के हमने भेजे थे उनको वापस.
Our athletes are the pride of this nation. They surely deserve better than being forced to sit in the biting cold in Delhi, in Jantar Mantar, protesting for, their basic rights.
No action against Shivaji, no action against R.S. Bharti, and there's no FIR. How can you get away by abusing, threatening governor?
Good evening, hello and welcome. You're watching Budget Buzz here on CNN News 18 with me, Poonam Burde. As the world faces recessionary fears and downgrade revised growth projections, India's economy remains a bright spot. The World Bank just recently said that India's GDP will grow at 6.9% in this financial year and will remain one of the fastest growing major economies. Experts have full confidence that despite the global headwinds, India's economy will sail through fairly smoothly. Now, India continues to be business friendly by attracting investments, by enabling capital investments, growing the startup ecosystem, even offering PLI schemes for several of these sectors, among many other initiatives that have been taken by the central government to keep the morale up both at an individual level and at the industry level. But will Budget 2023 serve as a stimulus for helping India to become the fastest growing economy, to stay the fastest growing economy? It's not just about fiscal prudence this time around. This budget is the last full-fledged budget Finance Minister Nirmala Sitharaman will present for this government's tenure. Add to that the 9 states that go to elections this year, in most of which the ruling BJP is the incumbent government. Many would say that this brings with it a tacit need to go the popular way. But can India afford a populist budget this time around? More disposable